So today what we'll be doing is we're going to be discussing the topic of what is a receivership, and we'll go through a few different phases of that. So number one, what is it and why do we use them? Number two, when might a court appoint a receiver? Number three, how does it impact a business? Number four, how do we actually obtain one? So what's the court process, the legal process itself for being able to obtain one? And then finally, I do want to let you know that we will now be discussing, after a summary, what it is that we intend to do during the next live. Just as a reminder, with respect to our firm, the reason why receiverships are an important piece to discuss is because when we say that we help business owners resolve complex disputes, we're not simply talking about general breach of contract matters or a simple fraud claim, not to limit the impact or value that those claims have. But a lot of our matters, since they deal with highly complex or at least highly adversarial disputes, oftentimes we need to do more than simply filing a lawsuit. Now, for those of you that have been following me for a while and remember some of the prior lives, we had discussed injunctive relief. We had discussed temporary restraining orders. And what those were provisional remedies. In other words, remedies that are offered during the pendency of a litigation to essentially stop a bad faith actor from doing something while the court continues to actually litigate and navigate the action. And the reason why provisional remedies are granted is because we don't want a plaintiff to go through an entire litigation, get to the point where they're able to obtain a judgment, only to realize that the business that they own or that the dispute they were having, whatever it is they were seeking, maybe it's real property, an asset, is suddenly rendered worthless. So imagine spending 3 years of your life in court, getting to the point and getting past depositions and discovery and motion practice, getting to the point of actually having a trial and a jury trial, and suddenly you get this judgment. And now because this bad faith actor got to do whatever they wanted over that 3-year period, this judgment you have, this piece of paper that you receive from the court, there's no value. There's no worth there, right? And in so that situation, the courts from day one had to come up with the means of protecting plaintiffs in litigation from having to deal with that scenario. Aside from the temporary restraining order and aside from the injunction, which frees or stop a bad faith actor from doing something, or an attachment of a bank account which stops the bad faith actor from spending or diluting the funds in a bank account, a receivership is something that goes a step further. So a receivership is a legal procedure where a court appoints an impartial receiver to take control of a business or property. And this takes place when there's a significant dispute among stakeholders that can impact business operations, financial stability, or even asset integrity. Receiverships generally are considered to be very versatile. They're used not only to maintain day-to-day operations of a business, they can also be utilized to investigate mismanagement of a company or even to focus on very significant financial misconduct. So with respect to temporary receiverships, they are governed by Article 64 of the New York CPLR, which is the Civil Practice Laws and Rules. And I'd like to go into a little bit of a discussion about when or what scenario would constitute a situation where the court might actually appoint a receiver. Generally speaking, imagine we're in a partnership dispute. You've got a claim that's filed in court. One party is suing another. It's two owners of a business, to keep it very simple. It could also be shareholders of a larger company where there's a separate C-suite and a CEO and a CFO and a CMO. And so it really, really depends on the situation. But to keep it very simple, let's say we have two partners in a business and each one has operative capacity, but there's a managing member of an LLC that's doing most of the heavy lifting of the work. And now it's discovered that this managing member of the company is committing some sort of fraud. Now, we know we can file a claim for fraud. We know we can file a breach of contract claim. We know we'd have a claim for breach of fiduciary obligations because members of an LLC, shareholders of a corporation, each owe a fiduciary responsibility to the other. But what can we do in the interim to stop the bad conduct from taking place? We discussed the injunctions in the past, but using a receivership takes us a step further. So in this situation, we could file an order to show cause to obtain a temporary receivership, which essentially would put this neutral third party in a position of power to allow them to take over the day-to-day tasks and conduct of the business. So the bad faith actor gets removed from the company. In the interim, they are not allowed to participate in the company. The receiver then takes over. So imagine the managing member, for example, is depleting the company bank accounts and is not paying its employees, is not focusing on the best interests of the business. This bad faith actor might even be starting a separate business that actually competes with this primary business. Well, the receiver steps in, they're appointed by the court. They then will report back to the court, but in the interim, their goal and role is now to completely take over day-to-day operations. They will make sure that payroll is being made. The receiver will make sure that AR is being taken care of. The receiver will manage the team of the company and make sure that they're doing the work they're supposed to ensure that business can continue to operate as usual. And what this winds up doing is it ensures continuity of the business, and it also mitigates disruption. And the benefit here is not simply to a plaintiff. Appointing a receiver in a partnership dispute is extraordinarily valuable. Why? Well, let's see. Now, imagine a situation where the plaintiff was able to obtain an injunction and the bad faith action stopped. Who's going to be running the business? Is it the plaintiff? Okay, fine. Then maybe a receiver is not needed. But if the plaintiff's not qualified to do the role that the bad faith actor was doing, a receiver can ensure that instead of the business essentially halting with productivity, we can maintain perhaps better than the status quo by having the receiver carry on business operations. So what does that mean not only for the business, it means for any shareholders in the company, they don't have to worry about the company going insolvent because of this dispute. For employees of the company, they don't have to be nearly as worried about the idea of, am I going to lose my job or am I going to be paid? Because we all know at the end of the day, a business is comprised of people. And people have lives and they have families and they have things they need to take care of in their own lives and financial obligations. So the receivership hopefully provides some assurances that the company can now operate independently, impartially, and can carry onwards without this worry of this complete interruption that could potentially send the business into bankruptcy. It's very important to remember that the receiver is impartial. So that means that they're not acting on behalf of one party in a litigation or another. They have a duty and a role, and they need to report to the court and provide updates with respect to what they're doing on behalf of the business and how it is that they are taking measures to safeguard the interests of the shareholders, the employees, even creditors, and then certainly shareholders. Another aspect where you'll see a receiver involved in a litigation that involves a business dispute is when there's a very significant allegation of financial mismanagement. Now, that claim might come through the lens of a breach of a fiduciary duty or fiduciary obligation, but the reality is that financial mismanagement is very serious. This often could be because there's a, for example, chief financial officer that is either not adequately doing their job, or worse, they are intentionally doing things that are causing harm, resulting in books and financial records that are simply not accurate. These types of claims can be very significant for the business's stability. They certainly can be abundantly harmful to the company's reputation. And so therefore, when you're dealing with a financial management claim and a receiver to be placed in a role to deal with it, you're generally going to be looking at some sort of forensic accountant or a financial auditor that has this financial capability to conduct a meticulous review of transactions, assess governance and practices, identify discrepancies, and then come up with a mitigation plan that will seek to improve the company's books and get it back on a path towards some sort of corrective measure, which hopefully yields positive results moving forward. This type of receivership is also very important, and while slightly different than the receivership of day-to-day management of the company, mitigating financial risks for a business, as you can imagine, is very important. Furthermore, there's another scenario where a receiver is going to be a tremendous asset, and that is really to preserve specific assets. Now, those assets can be intellectual in nature, such as IP, trademarks, copyrights, etc., or they can be physical, such as having a receiver take over real estate, real property, beginning to act as management. If management is not acting properly, then they can come in to ensure that payments are being made, that rents are being collected, etc. Assets need to be managed efficiently, and the receiver comes in to, again, minimize the risk of damage, depreciation, or any further misappropriation. So through this lens, the receiver is coming in to help maintain the business's overall value and operational capabilities. Now, moving on from there, now that I've given you a general background of what a receiver is and what they can do, one question that has come up is, well, in this particular scenario, when a receiver is appointed, who actually pays the fees of the receiver? Generally speaking, it will be the company itself. The income from the company that the receiver is operating will wind up paying the receiver's fees. But if that's not feasible, then the court itself, the judge may order that the parties wind up paying for the fees of the receiver. And this really leads into this other idea that the courts themselves have an expansive scope to render determinations such as this, such as who's going to be providing the resources, who's going to be paying the receiver. Next step of what we discussed, or what we were going to be discussing, is how do we actually obtain the appointment of a receiver? Well, the appointment of a receiver is subject to the New York Civil Practice Laws and Rules, Section 6401. And the standard states that the appointment of a receiver, in order to get one, since a receiver is considered to be an extraordinary remedy that we don't just give out, they're not able to do this by a standard of clear and convincing evidence, then they're not going to be able to obtain a receivership. Okay, so what does that actually look like? If you came to our law firm, or you went to any law firm and said, I'd like to file an order to show cause, or I'd like to move to not only sue a CEO or a business partner of mine, I have to have standing to do this, so I need to be a shareholder in the company, or I need to be one of the members of the LLC, and I'd like to sue them for a litany of causes of action, well, then we can talk about filing for a receivership. And how do we do that? So you get your summons ready, you get your complaint ready, where you unpack all of the factual details of what's taken place. You've set forth all the details of what's happened to date. Then you list your causes of action, the unjust enrichment, the fiduciary breaches, the misappropriation of corporate assets or corporate opportunities. You move on to claims for fraud potentially. And then instead of just filing that lawsuit and serving it, which puts the parties into litigation, you then file what's called an order to show cause for appointment of a temporary receivership. And through that lens, that order to show cause is sort of like an emergency application. You're running into court. You're saying, Your Honor, we need this to be addressed immediately. So now we are at the point where we've got an order to show cause that's being filed. In addition to that, there's further documentation that needs to be shown. You're going to want to take all the documentary evidence you can find, any proof of funds being dissipated, any financial reports, bank account statements, anything that's showing that bad faith conduct is taking place. That could also come through emails. It could come through text messages. It could come through social media channels, things being mentioned or indicated in writing. And you're going to compile that evidence, and that's going to all be attached to an attorney affirmation to show the court the proof of all the evidence of what's taking place. So now you've got your order to show cause. You have your attorney affirmation that contains all the exhibits with the documentary evidence to support your claims. You are going to be preparing a memorandum of law. And the memorandum of law will spell out the standards that we need to adhere to if we're to be able to obtain that receivership. And I'm going to talk about that in one moment. In addition, you'll also want to obtain affidavits by witnesses who can attest to things that they're seeing, witnessing experience, or documentation that they reviewed that was prepared by the bad faith actor, which would justify the inclusion and appointment of a receiver. I will say the plaintiff, him or herself, will also likely be preparing their own affidavit, which is a sworn statement, to set forth the allegations of what they've experienced and why they're moving for a receiver in the first place. Now that we know the actual procedural packet of documents that are needed to get to the court, the question is, what is it that we need to show the court in addition to all the facts and supporting documents, et cetera? What law do we need to explain to the court to ensure that we can get that receiver? So similar to a TRO, a temporary restraining order for a preliminary injunction, we need to show that, number one, acknowledging that this remedy is extraordinary, we need to adhere to the standard of showing clear and convincing evidence that the receiver is needed. Now, generally speaking, this scenario needs to show that there's some sort of sense of urgency. So number one, what do we need to really show? The first element is irreparable harm. We need to show that in the event we don't get some sort of injunction with the receiver appointed, that there's going to be irreparable harm to the company. Now, what is irreparable harm? Certainly, there's no one strict definition, but the general idea is that if we were to proceed to trial and obtain a judgment, and that judgment would be rendered worthless, the potential harm to the plaintiff is going to be considered irreparable. We also need to show a likelihood of success on the merits. And this is where people seem to sometimes get confused. Now, a likelihood of success on the merits doesn't mean we need to prove the case as if we're going to trial, but it does mean that we need to show the court that our claims are abundantly strong. So if we just go to the court and we say that, yeah, our claim for breach of contract, breach of fiduciary duty, we've got these claims, but we failed to provide proper evidence through affidavits, through documentary evidence to support why we need this receiver. If we can't show that we're likely to be successful on the breach of contract, the fiduciary breach claim, the fraud claim, guess what? Court's not going to grant a receivership. On that, balancing of the equities. So the balancing of the equities is the third element we need to show, and we need to show that it actually weighs in favor of the plaintiff. And what that means is that we need to weigh, the court itself is going to weigh the potential harm to the plaintiff if the receiver is not appointed against the potential harm to the defendant or other interested parties if the receiver is appointed. Now, usually, if the plaintiff is moving for a receivership, the balancing of equities, if they've established certainly irreparable harm and a likelihood of success in the merits, the balancing of equities is most of the time going to be in favor of the plaintiff. So it's going to be a rare scenario where the balancing of equities would actually be in favor of the defendant if irreparable harm and a likelihood of success on the merits has already been established. The next piece that one needs to show is that there is no adequate remedy at law otherwise. And what does that really mean? The courts are very hesitant to just go ahead and grant injunctions and to go ahead and grant receiverships. And the reason is because they want, generally speaking, the status quo to be maintained. And we need to show that if this doesn't happen, the status quo of the business won't be maintained. We're not only seeking monetary damages. So what do I mean by that? If monetary damages are enough to satisfy the plaintiff and there's no other potential loss, you're not going to get a receiver. An example of this would be the lender is owed money from the debtor defaults, the lender now sues, and the lender says, well, I'd like some sort of receiver to overtake the process of paying back the monies. The court's going to say no. Why is the court going to say no? Because what is the plaintiff's remedy? The plaintiff's remedy, assuming there's no separate collateral, is simply a judgment for monetary damages. But what about when we're dealing with the business? The plaintiff says that the defendant has defrauded the business out of several $1 million, is continuing to compete with the business. So on the one hand, the plaintiff certainly is seeking some sort of monetary judgment against the defendant, but is there something else at risk here aside from money? And in this instance, the answer would be yes, because essentially the company very well could fail. If we allow this bad faith actor continue to do what they're doing, and if we don't replace this bad faith actor with a neutral third party that can bring back the reputation of the company, gain the support of the employees, and now allow business to carry on, collecting on AR, dealing with payroll, signing new contracts, overseeing the sales team, then this company is likely to fail. And if that's the case, then there is something larger to lose, because essentially at the end of the day, the company that the plaintiff was suing to preserve is now going to be rendered worthless. So very important to keep that in mind. If money damages only are the solution, you're not going to be able to get a receiver. It's not going to happen, but it certainly is something that will happen if you can show that there's something else. An asset might be depleted, or its value might be deteriorated, or real property's value might decrease significantly. Or it could be an IP, something, some sort of branding. We need to maintain and protect and preserve the status quo of a business and protect assets. What's the end game? How does the receiver exit? Okay, so that's a good question. So ultimately, the idea would be when you get a provisional remedy of a receiver, they are temporary in nature. So to your point, there is an end game. Now, generally speaking, that end game really doesn't actually end until the trial completes or the matter resolves. So the idea is that the receiver takes the keys during the entire pendency of the dispute, and when there's a resolution, be it by a judgment or otherwise, the receiver then hands the keys back over. Now, there are scenarios where there could be an appointment of a receiver that extends beyond the final judgment in the litigation, but that's really a whole separate area. It goes beyond the idea of this as a provisional remedy. Moving along to a summary, benefits of a receivership are, number one, ensuring uninterrupted business operations. And I should say before that, there's a very important point, and this is kind of off the cuff and off the record of the general dialogue, but hey, I feel like discussing strategy because, we like to do a lot of strategy in our firm and strategizing, and I think this is very important. The mere threat of a receiver at times can wind up resolving the claim. And that's because when people are running a business, there's a lot of meaning behind it. There's a lot of value behind it. And if someone's doing something wrong and they just get hit with the lawsuit, some people are not going to be very happy. It's going to lead to, more contentiousness. It could lead to deterioration of the business even more. Some people aren't going to care. But the second they see that a receiver might be injected into their stead, so that way they're effectively removed from the company, the receiver's put in their place, and they're going to lose complete control. Imagine that. Because a lot of bad faith conduct, a lot of bad faith actor, a lot of fraudsters, people that engage in deleterious conduct, a lot of it is to maintain control. When it's understood what the implications will be, can often wind up initiating the conversation of reaching a settlement or some sort of beneficial resolution, whether that be a buyout or some sort of shift in equity ownership or day-to-day participation in the company. I hope that little tidbit is a valuable addition. In summary, receivers ensure uninterrupted business operations. So you'll always know that if a receiver is now conducting the day-to-day activities of the company, the court-appointed receiver should be doing that with efficiency and clarity, and they should be maintaining stability for the shareholders, for employees, for suppliers, for clients, and allow the business to continue unfettered and operate in hopefully a very positive way. These receivers, by the way, must come into court, dictated by a court-ordered schedule, to provide information and give updates about the status of the business. So the receiver is overseen by the courts, and there is that oversight to ensure that they are doing what it is they said they would do, which is, of course, to put the business in a better place than it was in, or at least certainly turn something around if it was in a very bad place. And this continuity that the receiver creates is essential for preserving revenue streams, sustaining essential services, and safeguarding the overall reputation of the business during challenging times. Receivers are also providing impartial oversight. So they play a critical role as an impartial intermediary appointed by the courts to oversee business operations and ensure that amidst contentious circumstances, there is an individual that you can trust that's acting fairly, that's acting unbiased, and that's seeking to do what's equitable. And by maintaining neutrality, receivers are able to uphold transparency and accountability within the business, which even if the plaintiff is a good faith actor, it's often difficult to get that high level of neutrality because in any type of litigation, often emotions are running high. And so therefore people aren't necessarily acting as objectively as we might want them to. So acting as guardians of integrity, implementing measures to prevent conflicts of interest, and promoting ethical conduct are all significant portions of what the receiver does. And that extends to impartiality over oversight of financial transactions, operational decisions, and any restructuring efforts aimed at resolving disputes.